Good morning, everyone. My name is Stephanie Goodwin, Acting Executive Director of Communications and Operations for BC's Office of the Human Rights Commissioner. We are meeting today on the unceded territories of the Lekwungen people, also known as the Songhees and Kosapsum nations. It is important to locate ourselves this morning because historical and ongoing colonialism, including dispossession of lands and human rights violations, has a deep and devastating impact on Indigenous people and communities. At the office, we recognize that we have an individual and a collective responsibility to work towards right relations with Indigenous people of these lands and the realization of thriving Indigenous legal and governance systems. Thank you for joining us for the release of We're Still Here, the report of the Commissioner's inquiry into detentions under the Adult Guardianship Act. The format of the press conference will be remarks from the Human Rights Commissioner, Kasari Govender. This will be followed by a question and answer period. At this time, Commissioner Govender will be joined by Carly Hyman, the office's senior staff lawyer, inquiries and investigations, the project lead for the inquiry. There are hard copies of the report available to those in the room, and an electronic copy is now available on our website at bchumanrights.ca/We're Still Here for those on the phone or watching online. To introduce the report, We're Still Here, the report of the inquiry into detentions under the Adult Guardianship Act, is BC's Human Rights Commissioner. Commissioner Govender began her work as BC's first independent Human Rights Commissioner in 2019. As an independent officer of the legislature, Commissioner Govender is uniquely positioned to ensure human rights in BC are protected, respected, and advanced on a systemic level. In her first 5-year term, her work included a public inquiry into experiences of hate during the pandemic, a report on systemic discrimination in policing, community-embedded research on a range of human rights issues experienced by people in British Columbia, public awareness campaigns about ableism and racism, and significant contributions and guidance to government that, among other things, informed the creation of the Anti-Racism Data Act and the Anti-Racism Act. Commissioner Govender was unanimously reappointed by the legislature for a second term beginning in September 2024. I invite Commissioner Kasari Govender to the podium.
Thank you to everyone joining us here today. I'm grateful that the Speaker tabled the Human Rights Commissioner's inquiry report into detentions under the Adult Guardianship Act in the legislature this morning, and I'm honored to be releasing it publicly now. This report is about the experiences of adults who are being abused and neglected, who are unable to seek support and assistance, and who are at risk of imminent harm. Based on what we uncovered through this inquiry, I have found that a significant number of vulnerable adults are being detained under this act through an opaque process with very little oversight. While adults are being held for their own safety, their rights to fair process, including knowing why they are being held against their will or what they can do about it, are often denied. While not every detention is unlawful, many are, and the harms disproportionately and unequally fall on people with disabilities, seniors, and people who are unhoused. These adults deserve the protection of the state. They deserved to be listened to and for their decisions about their bodies and how they live their lives to be respected as much as possible. They deserve to have public agencies and healthcare professionals be proactive in protecting their safety. They deserve respect for their human rights, their rights to liberty, to be free from arbitrary state interference, to safety within their homes and families, to substantive equality. Not only do they deserve respect for their rights, they are in fact legally entitled to it. The Adult Guardianship Act, or the AGA, is part of a suite of laws that are designed to work together to ensure that capable adults can make their own decisions and to provide tools for adults to appoint substitute decision makers or provide instructions for a time when they may be deemed incapable. The These laws are designed to ensure that adults' wishes are heard and respected if they become unable to make their own decisions, something I'm sure we all wish for ourselves and our loved ones. The AGA is designed to support an adult's autonomy and decision-making. This is reflected in its guiding principles, which include that adults are presumed to be capable of making their own decisions until the contrary is demonstrated, that adults are entitled to live in the manner they wish and to accept or to refuse help, and that adults should receive the most effective and least intrusive form of help when they are unable to care for themselves. Within the AGA framework, designated agencies, that is Community Living BC and the regional health authorities, are required to investigate reports that adults are experiencing abuse, neglect, or self-neglect, and where they are in a condition that affects their ability to make decisions. In many cases, staff do successfully find informal solutions to provide the adult with the support they need. However, designated agencies also encounter serious circumstances where adults are unable to consent to the support and assistance offered, and designated agencies believe that they are at imminent risk of harm. In other words, emergency situations where the designated agency believes that it must act without delay to protect the adult from harm, including death. This includes situations where an adult is being abused in community, is at a high degree of risk, and does not understand the danger they are in because of a cognitive impairment. In these circumstances, the AGA provides designated agencies with the power in Section 59(2) to take steps to protect the adult, which have been used to detain adults against their will for treatment and planning, and in some cases, for significant periods of time. When these emergency powers are used, there is a risk that a person's right to autonomy is not being properly balanced with their need to ensure their safety. This inquiry was undertaken to shine a light on, first, whether and to what extent vulnerable adults are being detained under the emergency provisions of the Adult Guardianship Act, and two, whether such detentions are lawfully permitted and in accordance with the province's human rights obligations. On its face, Section 59(2) of the Act, this emergency provision, is intended to be protective of human rights and was developed with the laudable goal of protecting adults in these circumstances from harm. I appreciate the difficult work of staff whose job includes protecting adults in these fraught circumstances, and acknowledge the emotional toll that this may take on healthcare providers, particularly in light of the limited community-based support services available to meet those adults' needs. I also recognize that these life-saving interventions may be welcomed by family and friends who may be at a loss for how to help their loved ones. This inquiry and my findings and recommendations are not intended to undermine the important goal of protecting vulnerable adults. Rather, this inquiry is about ensuring that when the state exercises extraordinary powers that interfere with an adult's liberty, that exercise of power accords with human rights laws and standards. The goals of the emergency provisions of the AGA and the goals of this inquiry are not mutually exclusive. We can and must take steps to protect incapable adults from imminent harm and also respect their human rights while doing so. In other words, protection from harm, which is the goal of the adult guardianship regime, must include protections both against the physical harms of abuse, neglect, and self-neglect, as well as protections for human dignity and fundamental rights. We can and must both protect people from harm and also not cause further harm in the process. One way we can prevent further harm is respecting the procedural safeguards required by international human rights law. We heard from one parent of an adult who was detained under the AGA emergency provisions, who said, quote, "It irreparably harmed us. It changed who we are. And so I know we were victimized. I know we were traumatized. I don't understand the scope of that. I know I have a lot of triggers. It's visceral. This is my son. He's older now. However, he's exceptionally vulnerable. They robbed us of our humanity, but we're still here." Throughout this inquiry, we have sought to place the perspectives and rights of vulnerable adults at the heart of our work on this issue. While we are only able to access the perspectives of impacted adults through their family members and service providers, it is the human dignity and human rights of detained adults, primarily adults with disabilities, seniors, and people who are unhoused, that is the scaffolding on which this inquiry is built. Well, this became a highly technical legal investigation into the operation of Section 5292 of the Adult Guardianship Act across the province. We never lost sight of why we were doing this and whose lives, safety, and rights were at stake. This report is dedicated to them. In the course of this inquiry, we gathered extensive data and records from the Ministry of the Attorney General, the Ministry of Health, the Public Guardian and Trustee, and the designated agencies. We held 2 community engagement sessions, conducted interviews with family members of adults who were detained under the AGA, and interviewed staff in each designated agency. We relied on Canada's international law commitments as the framework for our analysis. As a result of all this data and the analysis, I made 5 findings, which I alluded to earlier. First of all, detentions under this law impact a significant number of adults. Between 2018 and September 2023, so about a 5.5-year period, designated agencies detained 300 people in total for a total of 340 detentions. The median length of detentions was 6 days, where the maximum was 212 days. It is difficult to fathom how an emergency circumstance could last for hundreds of days, and therefore how detentions of such an extraordinary length could be justified under this legislation. The second finding is that transparency and oversight over detention are lacking. I found a lack of transparency both at a systemic and an individual level. Specifically, I found a lack of publicly available information on how this law is administered, a tendency to restrict information to representatives, legal counsel, and family and loved ones, with limited ability to seek independent review or oversight. We heard it can take a significant amount of time for family to learn the whereabouts of adults who have been detained. For example, one person described how she could not find her spouse for 3 months, even though her spouse was very ill and she had important information about her spouse's wishes and immediate care needs. The third finding is that adults' rights to fair process have not been adequately respected. Detention is a significant interference with liberty that must be accompanied by adequate safeguards to prevent arbitrariness. Yet procedural protections in this regime are sorely lacking. For example, in over half the detentions that lasted longer than 30 days, the adult did not receive written notification of their rights or the reasons that they were being detained. The fourth finding is that designated agencies who are detaining adults are doing so without legal authority. I found significant concerns around illegality that are raised in some, but not all detentions, including inconsistent and improper reliance on the law, evidence of detentions beyond the time necessary to address the emergency circumstances, as I've already mentioned, and failure by designated agencies to apply for court authorization for ongoing support for adults. And the fifth finding is that the disproportionate impact of detention practices on seniors, people with disabilities, and people who are unhoused, including people with mental health and substance use issues, results in systemic discrimination. I conclude that the current approach to detention under Section 59(2) of the Adult Guardianship Act is discriminatory because the harms of detention, including the fact that many adults are detained beyond the legal scope of the authority granted by the AGA and without due regard to their procedural rights, are disproportionately experienced by seniors, people who are unhoused, and people with disabilities. In fact, 94% of detained people have disabilities and 70% are seniors. This is not to say that any and every detention of vulnerable adults who are apparently abused or neglected is necessarily discriminatory, but it's to say that the current system and practices for detention do result in inequality. As a result of these findings, I made 10 recommendations to the Ministry of the Attorney General, the Ministry of Health, and the designated agencies, including designated agencies immediately stop detaining adults for longer than the duration of an emergency and ensure that all detained adults receive written reasons for why they are being detained. To provide legal advice and representation to all adults who are detained. Develop provincial data standards, making data mandatory and requiring annual public reporting. Develop mandatory provincial training. Consult on the role of police under the emergency provisions of the AGA. Introduce amendments to the legislation to clarify whether detention is indeed allowed in emergency circumstances and to impose time limits. Develop provincial guidelines to support the implementation of legislative changes to ensure that rights are respected. Assess and report publicly on community health resources that are required to reduce the number and length of detention of adults under the Act. Create an independent mechanism for detained adults to challenge their detentions and the conditions. And finally, to create an independent officer of the legislature with oversight of detentions and healthcare facilities. In 2019, the BC Supreme Court released a decision regarding a woman who had been detained by Fraser Health for over 11 months under these emergency provisions of the AGA. In that decision, the court found that the health authority's decision to detain her without a court order, without providing her with reasons for detention or access to counsel, was inexplicable and violated the Charter of Rights and Freedoms. In early 2021, recognizing that concerns and criticisms regarding the province's adult guardianship regime had been building, a working group of the Ministry of the Attorney General, Ministry of Health, and the Public Guardian and Trustee was established to conduct a comprehensive review of the province's adult abuse and neglect framework. Through the working group's consultations, the government heard significant concerns about how this system worked, including concerns about adults being detained for lengthy periods of time without court oversight or other procedural safeguards. I reviewed documents that suggest government recognized the importance of taking timely and significant action and was aware of concerns about continuing risk of harm to vulnerable adults. Despite this, government has not proposed any legislative changes or made any other significant policy changes to date to protect the rights of vulnerable adults. However, I'm very pleased to say that I understand that government and designated agencies will be taking some such steps now as a result of our findings and recommendations in this inquiry. Full implementation of these recommendations will bring the government and designated agencies into compliance with international and statutory human rights law and ensure that the rights of some of the most marginalized people in the province are respected. As I mentioned at the beginning, this report provides a fairly technical overview of how the AGA regime operates in emergency circumstances. But it is the people who are directly impacted who form the heart of this report. It is our elders who need support to be safe and as safe and independent as possible. It is people with cognitive disabilities who need to have their voices heard. It is family members who want their loved ones to be safe, but not to be isolated or cut off. This report shines light on experiences that many of us in the general public have never heard of, but have been well known by those who lived them, by the advocates who have worked tirelessly for change, and by the provincial government. We cannot let these issues recede into the shadows again. I look forward to seeing my recommendations made real and vulnerable people being treated with the respect and dignity to which they are entitled. Thank you for being here today. I look forward to your questions.
Thank you, Commissioner Govender, for sharing the important findings of the inquiry. This concludes the remarks portion of the press conference. I will now turn it over to Lindsay Bertrand, Manager of Communications for the office, to moderate the question and answer period.
Thank you, Steph. Thank you again, Commissioner Govender, for your comments. So as Steph mentioned, we've now reached the portion of our press conference where the Commissioner and Carly Hyman, our Senior Staff Lawyer of Inquiries and Investigations, will take questions. Media on the phone line, you may queue up to ask a question by pressing *1. For media in the room, if you're ready to ask a question, please raise your hand or otherwise indicate that you have a question, and I'll call on you on a first come, first served basis. I'll ask that everyone keep their questions brief and that you limit yourself to just one follow-up after you receive a response to ensure we have time for everyone. And we'll start in the room today, and I see that Mark's already got the mic, so this is Mark Paget, BC Today. Please go ahead.
Hi. Can you talk about this within the broader context of this push by the government and the opposition to expand involuntary care in BC to encompass people with substance use disorders and things of that nature, and how this act intersects or doesn't intersect with the Mental Health Act?
Yes, thank you for the question. So there are some really key differences between the Adult Guardianship Act and the Mental Health Act, which is where the conversations have centered recently around involuntary detention. So without weighing into the merits of the Mental Health Act regime, there are significantly more protections for oversight and procedural protections built into the Mental Health Act regime for those who are detained than there is in the adult guardianship context. The AGA is also focused on protecting people from abuse and neglect, where the mental health context is providing people with psychiatric care, with mental health services. There are also different criteria under both regimes in terms of what will lead to somebody being detained. So there are distinct differences. The common thread here is that when people are detained in healthcare facilities, there needs to be independent oversight and there needs to be procedural protections in place.
And now, you mentioned the disproportionately affecting seniors and unhoused people. Is this being used to detain people with substance use disorders?
There are significant numbers of people who are being detained that have mental health disorders and substance use issues, and as I say, a particular impact on people with disabilities.
All right, thank you. We'll go to the phones now. We've got Michelle from the Tyee. Michelle, you can go ahead.
Can you hear me?
Yes, we can hear you.
Okay. I was just wondering if the commissioner could explain a bit more about the process of people being detained. For example, I'm just trying to wrap my head around what would happen for a spouse to not be able to locate their partner for 3 months, or someone being detained more than 200 days without being read their rights. How does that process kind of unfold?
People can be detained in a number of ways. We did hear about some involvement of police, although that's not specifically authorized under the legislation, where the police can be involved in doing a health check on somebody and ending up taking them to a hospital or acute care facility, and they end up being detained under the Adult Guardianship Act. There is a fair amount of secrecy around these detentions, on both an individual basis and a systemic level. So in terms of the individual basis, for many people, the healthcare facility will not reveal where somebody is being held, and not reveal anything about their case, including you heard reports of not being disclosed to loved ones, not being disclosed to legal representatives, and even lawyers having trouble finding out where their clients might be or the conditions under which they're being held. Do you want to add anything to that?
So the Act provides the designated agencies with authority to enter an adult's home, use reasonable force, and transport them to a safe place. Typically, adults are transported to hospital, and it's in the hospital where they're detained, generally in acute care.
All right, Michelle, do you have a follow-up to that?
Yeah, I did. Are these kind of abuses that we're seeing? Is this a lack of training, where people don't understand what powers they're exercising, or is this more kind of systemic discrimination against someone who is senior or someone who is disabled, where they just don't, as far as this process understands, they just don't get right?
It's yes and. So the roots of why people are being held, I think there's clear problems in the law. So the Adult Guardianship Act doesn't actually authorize explicitly detention, which is the first problem. So the health authorities, the designated agencies, don't have clear authority to detain. And so there are disparate practices across the province of how this legislative regime is interpreted. There are health authorities who reported that they did not detain anybody over this period, others who detained hundreds, as you've heard. So first problem may lie in the law. Certainly there may be problems of bias and stigma, both built into the system and on an individual basis. Lack of training is another issue, and it's part of one of our recommendations for change. Lack of guidelines for consistent practice across the province, again, forms one of our recommendations for change and is one of the roots of this issue. And then a lack of institutional oversight. So even if detention is explicitly authorized into the legislation, the other legislative changes need to include, for example, the creation of both a mechanism that individuals can appeal or seek legal redress, seek a means to be released or to challenge the conditions of their detention, as well as the law should create a systemic oversight mechanism, of which we don't have any at this point built into the Adult Guardianship Act.
Thank you, Commissioner. Staying on the phones, we've got a question from Ashley Jawanu, Canadian Press. Ashley, you can go ahead.
Hi. Thank you. I think this overlaps a little bit with the last question, but one of your findings is that agencies are detaining adults without legal authority and that detentions are occurring under doctor's orders, which sounds like technically is not allowed. So I guess I'm hoping that you can explain to people what legal authority that agencies actually have to detain people, or what authority they're using, and what you found in terms of how it is not being used appropriately.
So Section 59(2) of the legislation provides a number of options for what designated agencies can do in emergency circumstances where an adult is found to fit the criteria. I mean, we've discussed, as we've discussed already, so the criteria being, is this person incapable of giving consent? Are they apparently neglected and abused, and are they at risk of serious imminent harm? So if those criteria are met, there are a number of options for what health authorities or designated agencies rather what steps they can take. Nowhere in that section is laid out that they can detain people, but each aspect of that detention, that section of the legislation has been interpreted by health authorities to provide supposedly to provide some authority. So we asked health authorities to identify or designated agencies rather, to identify what subsection they were detaining people. And for example, they can transport someone to a safe place. Some people are relying on that section to justify detention. Some people there is a allowance to take any other necessary measures. Some designated agencies are relying on that authority. But as I say, there is no explicit authority, and it is worth noting that we are not aware of any other regime in Canada, not just in the adult guardianship context, but in any context in which detention by the state is allowed without there being explicit authority, there being timelines in place, and without there being oversight in place. So this is, as far as we are aware, a unique piece of legislation with little legal authority to actually take the steps that are being taken.
Ashley, do you have a follow-up?
Yeah, I'm hoping you could just give me a little bit of context in terms of how old this legislation is, when the last time was anyone looked at it, and how long these problems have been raised with the government. So
I'm going to pass to my colleague, or ask what the... Thank you. It was passed in 93. It came into force in 2000. There have been concerns raised by many who are in this space to government that entire time. So I spoke briefly about the AH case, which is a case that was decided at BC Supreme Court, in which the court raised serious concerns with how the operation of this statute happened in the case before the court in that case. And then there were also other concerns raised to government, which is what caused them to form this working group in 2021 to look at those concerns. And as I say, I saw documentation that that I believe that the government was aware of these concerns, aware that these issues were continuing, but no action has been taken to follow up and to change the regime.
All right, thank you. Any other questions? Any other hands? No one on the phone? All right, so thank you so much, everyone, for your questions and your time. If you would like to follow up with a one-on-one interview with the commissioner, she'll be available in this room until noon. If you'd like to schedule something for later on, particularly for those on the phone or watching the live stream, please contact our office by emailing media@bchumanrights.ca, and we'll get right back to you. Thank you again, everyone. Thank you, Commissioner Govender, Ms. Hyman, Stephanie Goodwin. This concludes today's media availability from BC's Office of the Human Rights Commissioner.